the powers of the contempt of court, and when it is face off with the free speech, that is one of the most cherished freedoms that we talk about. Before I begin with the formal introduction of the guest for the day, may I request our Director and Dean, Professor Dr. Puri Pokhriyal ma'am, for her introductory remarks.
Thank you, Vikas. At the outset, I wholeheartedly welcome distinguished Professor Venkat Iyer from Ulster University, the university which is a partner university of NIRMA. We are so glad to host you for this International Teaching Month. The whole purpose of this International Teaching Month is to have a diverse views from different walks of life on different themes. And we are so glad to have you for a very interesting talk today. And when we are talking about this thing, just now I was just going through the government has notified the Information Technology and Digital Media Ethics Codes and Rules 2021. And, the whole, for the last 6 months, the whole digital, free speech on the digital media has developed a different kind of a jurisprudence, not only in India, but in US as well. So we are having a new developing actors, who are controlling this free speech zone. Thank you, Professor Venkat Iyer, for selecting this topic and being with us today. And I also welcome Professor Paul to this session. Thank you so much.
Thank you, ma'am. So we are very fortunate to have with us Professor Dr. Venkat Iyer sir with us. Just to give a brief introduction, sir is the professor and head School of Law at Ulster University, UK. Sir teaches media law, constitutional law, and business laws. And he's also the director of educational partnerships and international affairs at the university. He's a trained mediator as well, and he also has to his credit to have worked on a program on continuing legal education, which was as a part of the World Bank project. And he's also been a consultant to a number of government and non-governmental organizations as well. So on behalf of the Institute of Law, NIRMA University, I cordially record my welcome to you, sir, for this session. And I also welcome Professor Paul, who is also here. He's the Dean of Global Engagement. And to all the participants, you can put up your questions to me in the private chat box, which will be taking up at the end of the session. So over to you, Venkat sir, for the session. Thank you.
Thank you. Hello and a good afternoon. Let me say first of all that I'm very grateful to NIRMA University, to Shreya Srivastava, to Vikas Trivedi, to Purvi Pokhriyal, to Rameshan, and others for including me in your International Teaching Month. I wish I was there in person as I was last year, but that is not, of course, feasible in present circumstances. So we must remain content with the next best alternative, namely of this chat over Zoom. The subject on which I've chosen to talk to you today is, I thought, quite topical given certain recent developments in India with which I'm sure you're all familiar. Those developments should, in my view, make all of us think deeply about some fundamental issues concerning the importance and the width of free speech in open societies, regardless of one's political ideology or legal philosophy. Let me set out my stall straight away with a couple of propositions which I will expand on in the course of this lecture. First of all, I am a free speech maximalist, but not a free speech absolutist. Secondly, I believe that the judiciary is far too important an institution in a democracy to be left to the judges alone, which means that it must be exposed to public criticism when needed. Let me explain. First, the nature of free speech. I don't need to tell you about the central position that freedom of expression occupies in all open societies. Free speech is essential for such a society for a variety of reasons which need not detain us now. But should freedom of expression be absolute? Certainly not, because like all other freedoms, it has the potential, if used in certain ways, to harm others, and that should be avoided. This means that some restrictions can be put on free speech. I would argue that the dividing line between acceptable free speech and unacceptable free speech is, does the speech in question have a tendency to incite violence? Mind you, I mean violence, not any lesser harm. A colloquial way in which I can put this is to say that the freedom of my fist ends where your nose begins. In other words, I should have the right to swing my fist as much as I like, but I cannot, in doing so, hurt someone else. And that is the philosophy which the Indian Constitution also accepts by imposing the concept of reasonable restrictions in the chapter on fundamental rights. Under Article 19(1)(a), everyone has the right to freedom of expression, but that right can be restricted on certain grounds. One of those grounds is contempt of court. Now, what is the rationale for contempt of court, which for the sake of convenience, I shall shorten to contempt? It is essentially to preserve public confidence in the judiciary, though other justifications have also been offered, for example, to protect the authority of the courts or to uphold the majesty of the law. There are many practical ways in which contempt law allows for those objectives to be achieved, and I shall discuss them at length shortly. But the one thing that contempt law is not intended to do is to protect the reputation of individual judges. This is an extremely important point on which I want to spend a few minutes because there is a lot of misunderstanding about it, particularly in India. And that misunderstanding goes right to the top of the Indian judiciary. Just a few days before he assumed office, the current Chief Justice of India made some observations in a TV interview that he gave, I would say about a week before he took office, which brought out this confusion rather worryingly. He was complaining about media criticism of judges, and he said that those at the receiving end of such criticism felt harassed. Nobody, he's quoted as saying, likes it. Everybody is not thick-skinned enough to ignore such criticism. His anger appeared to be directed especially at criticism conveyed through social media. The anger was followed by an expression of helplessness because he continued to say, we cannot do anything to this kind of media, that is, he's referring to social media as of now. We don't know what steps to take. They are not only scandalizing, but tearing apart people's reputation and judges' reputation. Clearly, the judges' observations revealed a lot of confusion, and that confusion exists across the judiciary. And also, I might add, across society. The confusion between contempt and defamation has serious consequences. Among other things, those sued or, in the case of India, prosecuted for defamation have many more defenses than those charged with contempt. Also, the scope for cross-examining the complainant in a contempt case, that is the judge, is almost non-existent, whereas in a defamation case, such cross-examination is possible. In those circumstances, it is not surprising that some judges find it easier to deal with criticism they don't like via the contempt route rather than via the defamation route. But I want to reiterate the point that defamation and contempt of court are two separate and distinct things. It is certainly possible that a certain remark can be both contempt and defamation, but any action that is sought to be taken cannot be combined. What then is contempt of court? What purpose is it intended to serve? The starting point for answers to these questions would be to look at contempt as one of the limitations placed on freedom of expression. So if you look at the Indian Constitution, I've already referred to Article 19(1)(a), which guarantees the right to freedom of expression. But another part of Article 19, namely Clause 2, says that the state may restrict free speech on the grounds of contempt, among other things. Crucially, any restrictions that are imposed must be reasonable, which is a point that must be kept in mind at all times. In very broad terms, the concept of contempt involves any speech or action that is likely to interfere with the administration of justice. And therefore, this area of the law requires a balancing of two competing interests: freedom of expression on the one hand and administration of justice on the other. And that balancing has to be done sensibly and sensitively. Now, what does interference with the administration of justice mean? There's a lot of guidance given in statute and in case law. Contempt in India is governed by codified or statute law in the form of the Contempt of Courts Act of 1971. But this law should be read in conjunction with case law, including from England and other common law jurisdictions. It is also relevant to keep in mind two provisions in the Constitution, Articles 219 and 142, which give the Supreme Court and the High Courts the power to punish for contempt. The Contempt of Court Act defines contempt in a lengthy way, and I will not bore you with the details. Suffice it to note, first of all, that there are two broad types of contempt: civil and criminal. This division is not quite the same as the general distinction that is drawn between civil and criminal law. So please keep that in mind. And please also keep in mind that there is scope for overlaps between the two types of contempt. Civil contempt essentially consists of willful disobedience of court orders or processes, or willful breach of undertakings given to a court. Note the word willful, which is intended to keep out accidental or unintentional acts. Generally speaking, civil contempt has not caused any major problems over the years, although this branch of the law has generated a lot of case law and is not uncomplicated by any means. Let me deal with it quickly before I get to criminal contempt. First, about disobedience of court orders. If you're faced with an order whose wording is not clear and you do something which the court subsequently says was a violation of the court order, you may be able to argue that the ambiguity in the order should excuse your non-deliberate act. But it's always a good idea, when you're in doubt about a court order, to go to the court and seek clarifications. This is usually done through the court registry. Never approach a judge directly. And please don't follow the Indian habit of calling a judge on his mobile number, even if you have that number. What happens if a judge passes an order which is patently or manifestly wrong? Such things do happen from time to time. Unfortunately, however convinced you are about the mistake of the court, you cannot disobey the order. What you should do in such circumstances is to have the order overturned in appeal. Remember also that if you willfully breach an undertaking that you've yourself given to a court, that can also be contempt. Similarly, tampering with court documents. Then there are automatic restrictions on the reporting of some cases. For example, the names of victims of rape should never be disclosed. So even if you know the name of a rape victim, you should not publish it unless there is an explicit order allowing publication. And now to criminal contempt, which is usually more problematic. The law defines this as any act which either scandalizes or lowers the authority of a court, or which prejudices or interferes with a judicial proceeding, or which obstructs or interferes with the administration of justice in any other way. I've, of course, simplified the definition to make it easier for you. And I should add that the law also covers acts which intend to do any of those things. Now, there are many rules about the use of the contempt jurisdiction. Firstly, that the power of contempt must be used sparingly. Secondly, that it must only be used in cases involving extremely serious attacks, which are likely to shake the public's confidence in the judiciary. Thirdly, that it must only be used where the case for the prosecution has been made out clearly and beyond reasonable doubt. Fourthly, no judge who has been affected by the criticism should hear the case. Fifthly, the accused person must be given a fair and reasonable opportunity to defend himself, as well as a chance to tender an apology. Finally, if the apology is tendered in good faith, the court has a duty to accept the apology and close the case. I want you to keep all these principles in mind as I take you through some cases. There are various circumstances under which contempt can arise. First, what is called contempt in the face of the court, for which judges have the power to punish summarily, that is, on the spot, without any trial being held. This type of contempt happens inside or very close to a courtroom. An example that would be familiar to Indians is where a litigant who loses a case gets angry and throws his shoe at the judge, sometimes in addition to hurling abuse as well. I understand that this once happened in a case being heard by Justice Hidayatullah, who went on to become Chief Justice of India. Apparently, the judge very calmly asked his court staff to return the shoe to the litigant, saying, "He has lost his case. I don't want him to lose his shoe as well." Nowadays, this type of contempt happens more commonly when people forget to switch off their mobile phones in court, with the result that proceedings are disrupted when a phone rings unexpectedly. I would say that most of the time, the judge simply lets the offender off with a warning. Interestingly, there have been few occasions when the mobile phone in question belongs to the judge, and that results, of course, in a deep red face on the bench. Perhaps I should give you an amusing story of a contempt in the face of the court from England. This happened in 1975 when a young man called Stephen Balogh, who was training to become a solicitor, had to attend a long trial as part of his training. He got bored and decided one day that he'll make things a bit lively by secretly introducing some laughing gas into the courtroom by emptying a can of nitrous oxide into the court's air conditioning system. To his misfortune, he was caught by the security guards before he introduced the gas and was duly charged with and convicted of contempt in the face of the court. Now, remember that if his plans had succeeded, there would definitely have been obstruction of the proceedings. But when he appealed, the appeal court let him off, arguing that action should only be taken in very rare cases where there was a disturbance actually caused in court. But such leniency is not shown in India. And some years ago, I heard of a situation in which a judge in a lower court somewhere in Maharashtra had made a witness who had come late to the court by a few minutes stand on one leg for as many minutes as punishment for his lateness. Most people will recognize this as nothing but a desire for vengeance, which is not the purpose of contempt law. There's also the ego factor, which comes into play frequently. Let me give you two examples from India. Many years ago, I read a newspaper report which said that a certain High Court judge called I.M. Kudusi from Allahabad had held court on a railway platform in Delhi and punished an official with contempt after the official had denied him a sleeping berth on a train. Even by Indian standards, this appeared to me to be outrageous. But I decided to keep an open mind and investigate, because I know that the quality of media reporting in India has fallen sharply over the years. So I phoned the judge, who was surprisingly very willing to discuss the case with me. His version of the incident was that the railway official had been drunk and had misbehaved with him. Whereupon, he said, he had, as a last resort, revealed his identity and threatened the official with contempt. That version was plausible, and I was willing to give the judge the benefit of the doubt, especially because it is not uncommon in India for government officials to behave in a high handed manner towards ordinary folk. But many years later, I discovered that the judge in question was a notorious character, so notorious, in fact, that he had himself been arrested for corruption. That made me wonder if the story he told me was at all true. A second case involving a situation of don't you know who I am happened more recently in Kerala. This resulted from a High Court judge called P.D. Rajan, who visited a temple away from his normal place of residence and in Mufti. On reaching the temple, he summoned two policemen who were standing on duty and ordered them to fetch a lady doctor who was working in a temporary clinic at the temple. When the policeman asked Rajan politely for his name so that he could give that information to the doctor, Rajan refused and arrogantly reiterated his command, saying that the doctor would know even without his name being mentioned to her. It turned out that the doctor was his own wife. But the policeman knew none of this, nor did they know that the person whom they were in conversation with was a judge. Throughout the conversation, they addressed him, as is customary in Kerala, as Cheta, which is elder brother, a bit like Bhai Sahib in North India. But Rajan took deep umbrage, considering it to be not sufficiently respectful. The policeman also told Rajan politely that he would have to fetch the doctor himself. This angered him, and he proceeded to take down the badge numbers of the policemen. And the next thing that happened was that the policeman received summonses to appear before him in the High Court a couple of days later. He berated them for misbehaving at the temple and forced them to sit in a corner of his courtroom for several hours and copy down a chapter from the police manual relating to a constable's duties. Conduct such of this should, I think, make anyone's blood boil. But such is the state of justice in India that the policemen had to suffer their humiliation in silence. The punishment that they were meted out had no basis in law, but it could only be set aside in appeal, and it was too much to expect the policemen to go through that process after the treatment they had received, especially without any external help. Next, I want to turn to the form of contempt which is called trial by media. It is a catchy phrase, and it has profound practical implications. In every civilized society which believes in the rule of law, anyone who is accused of an offense is entitled to a fair trial. This means, among other things, that only the circumstances relating to and with admissible evidence are to be considered by the judge, not anything extraneous, such as the accused's previous conduct, although previous conduct and in particular prior convictions will become relevant at the time of sentencing. At the same time, there is another important countervailing interest in all free societies, and that is the right of citizens to know about the administration of justice, which includes information about court proceedings and which also crucially includes the freedom to discuss within reasonable limits cases of public interest. How to balance these competing interests has always been a challenge in open societies. The general rule is that cases can be discussed in the public square or in the mass media, as long as the discussion is unlikely to put such pressure on whoever decides cases, in India judges, and in countries like England either a judge or a jury, that their objectivity is impaired. How much pressure is tolerable depends to some extent on conditions prevailing in a particular society. What should be prevented is mass hysteria, the lynch mob effect, which will make a fair trial impossible. In this context, if you look at the Contempt of Courts Act 1971, it says that anything which prejudices or tends to prejudice judicial proceedings would be contempt. Let's look at a few examples. The one that is frequently cited in India is the Arushi Talwar case, where a young lady had been murdered inside her home along with a domestic servant of the family. I understand that media comment on the case was ferocious, with most commentators asserting with absolute conviction that the girl's parents were the murderers, despite the evidence being either very slim or non-existent. The police apparently aided and abetted the media hysteria, with one very senior police officer making patently defamatory allegations against the parents even before the trial had begun. I also understand that many newspapers produce reports each day anticipating the court's proceedings that day. Despite all this, the accused parents were ultimately acquitted by the Allahabad High Court, which I was told was seen as a bit of a miracle given the pressure that was put on the court. But there's another side to this coin, which also cannot be lost sight of. It has to do with a myth perpetrated by many that as long as a case is pending, no one should comment on it. That would be just as wrong as media hysteria. Not only is it acceptable for court proceedings in cases, however sensational, to be reported, but a certain amount of discussion of cases is also permissible. What should not be done is to prejudge the outcome of the case in such a way that it has the effect of putting undue pressure on the court. In India, of course, it's only judges who hear and decide cases, unlike in countries like England, where juries are involved. The risk of influencing juries is much higher than the risk of influencing a judge. And that is the reason why the sub judice rule, as it is called, was put in place. This rule should therefore be applied more loosely in India. The tendency on the part of people to use the sub judice rule as an excuse to prevent information being made available to the media or to the public must, I think, be strongly resisted. Another type of contempt which has been causing huge problems in India is called scandalizing the court or scandalizing a judge, depending on the context. And it consists essentially of attacks that are so scurrilous that they're likely to undermine or shake the confidence of the public in the administration of justice. In times long gone by, of course, the threshold for scurrilousness was quite low, and even relatively mild attacks on judges would be considered unacceptable. But as the years went by, prosecutions for scandalizing became rarer and rarer. And by the 1980s, even the House of Lords admitted that this offense had become obsolete. There have been many occasions in recent years when the media in the UK have criticized judges sharply, and yet no action was taken. Some of those examples have been recently cited in India in the course of the debate over the Prashant Bhushan case. So I shall not spend too much time describing them. Two of the most prominent are worth noting. First, the action of a newspaper in publishing the photographs of 3 judges of the House of Lords, or actually it was a Court of Appeal, I think, upside down on the front page under a huge headline screaming, "You fools," after those judges had given a controversial ruling in the Spycatcher case in 1987. No, that was actually of the House of Lords itself. And secondly, more recently, the publication of a similar headline by another newspaper, which called the judges who decided the Brexit case at an intermediate level enemies of the people. In neither of these cases was any action taken because, as British judges have frequently stated, they consider their shoulders to be broad enough to accept such criticism. I would argue as well that if a judge has the necessary self-confidence and is not insecure, as sadly many judges in India are, he'll be able to brush off the unfavorable comment without batting an eyelid. Let's now turn to some Indian cases on scandalizing. One of the first to arise involved the former Chief Minister of Kerala, the late Mr. Namboodiripad. As a communist, he was not a great fan of judges trained in the Anglo-Saxon tradition, as all Indian judges are. So during a press conference, he said some rude things about judges, and he called the judiciary an instrument of oppression, and judges as dominated by class hatred and class prejudice, who would instinctively favor the rich against the poor. When charged with contempt, he defended himself, arguing that he had no intention to disrespect the judiciary, but was simply giving expression to the Marxist philosophy to which he subscribed. This defense was rejected, and he was fined 1,000 rupees or asked to suffer imprisonment for 1 month. He appealed the decision to the Supreme Court, which in a lengthy judgment upheld it. But the Supreme Court reduced the fine to a token 50 rupees or 1 week's simple imprisonment in lieu. Many people thought the Supreme Court was wrong in taking the line it did, not only because Mr. Namboodiripad had specifically and unreservedly accepted that the verdicts of the courts needed to be respected, despite his criticisms of the judiciary as a whole, but also because the judgment signaled an unreasonable restriction on freedom of expression. Let barking dogs lie was the critics thought a better approach to take in the face of such criticism. Now, sticking with criticism of judges, there was one slightly unusual and entertaining case which arose in the Delhi High Court in 2001. It concerned a little-known magazine called Wa India, which published an article that revealed the results of a survey apparently carried out by the magazine about the integrity and competence of judges attached to the Delhi High Court. In the survey, some 50 senior lawyers practicing in that court were asked to grade the judges on the basis of personal integrity, depth of legal knowledge, and quality of judgments delivered. Unfortunately, no copy of the article in question is available, so I've had to rely on the judgment given by the court, which is short on details. Anyway, when the editor of the magazine was charged with contempt, she quickly apologized. But the court was not satisfied that the apology was genuine, although in the end it accepted it by a majority and ordered not only that sales of the issue in question will be immediately and comprehensively stopped and all existing copies seized, but also that the apology tendered will be published in 5 national dailies. An interesting aspect of this case is that initially media reporting of it was banned, but that ban was lifted after protests from journalists. I now want to discuss one major case, which was the trigger for an important change to the law on contempt in India. That case is V.M. Kannade versus Madhav Gadkari, and it began in the Bombay High Court, which gave judgment in 1989. The facts are most interesting. The defendant, Madhav Gadkari, was a well-known Marathi journalist who wrote a popular column in Lok Satta newspaper, of which he was also the editor. In one of his columns, he discussed some worrying trends in the Bombay High Court. Specifically, he made 3 criticisms which became the subject of the contempt case. The first point he made was that one of the judges of the High Court was amenable to the seductive charms of a certain lady advocate, with the result that this judge would pass orders favorable to the party for whom the lady in question appeared. The second point Gadkari made was that there was another judge in the High Court who was deaf and had the habit of switching off his hearing aid when he did not want to hear an advocate, any advocate. And the third point he made was that the Motor Accidents Claims Tribunal, which hears cases for compensation in relation to motor accidents, was, in his words, a plain racket. Because, among other things, two-thirds of any compensation awarded was swallowed by the lawyers and judges involved in the cases. He also made the point that the tribunal was situated on the fifth floor of a building whose lift was perennially out of order, which, considering that it heard accident cases, was disgraceful, since many of the plaintiffs would have suffered injuries that would have rendered them disabled and therefore incapable of climbing stairs. On being charged with contempt, Gadkari indicated, in effect, that he stood by everything he said and was willing to prove his allegations. The law, unfortunately, did not allow that. Another part of Gadkari's defense was that he wrote the article with the best of motives, with a view to improving the sad state of affairs prevailing in the judiciary. Neither of those arguments appealed to the judges, and they held him guilty, sentencing him to a fine of 100 rupees or to imprisonment for a week in case of default. Mr. Gadkari was unhappy, and he filed an appeal in the Supreme Court, which promptly stayed the judgment. Sadly, a few years later, Mr. Gadkari passed away, which means that his appeal would have abated. But that was not the end of the story, because Parliament decided in 2006 to amend the Contempt of Courts Act to allow truth to be pleaded as a defense to a contempt charge, provided that the defendant could also show that there was some public interest in such a defense. Also, that there was good faith in raising that defense. One can consider that amendment as a legacy from the Gadkari litigation, although a recommendation for such an amendment had also been made in 2002 by a commission that had been formed to review the working of the Constitution. What does that amendment mean in practice? It means that while a person charged with contempt can attempt to prove the truth of what he had said, he cannot bring in matters that would not be in the public interest. An example might be a statement which makes scurrilous allegations about a judge's private life, which are wholly unconnected with the performance of his duties, and then attempt to justify those allegations in open court during contempt proceedings, which of course can then be lawfully reported in the media. This would amount to washing dirty linen in public, which cannot do any good for public confidence in the judiciary. But we need to remember that such a situation might give rise to a defamation action by the judge. There's one case where I see the possibility of the truth of, or the defense of truth being used if contempt proceedings had been brought. But as far as I know, no such proceedings were actually brought, and rightly so. It is a case which happened in Chandigarh, and it had to do with judicial corruption. The facts are as amusing as they're astounding. A bag of money containing 15 lakhs of rupees was delivered at the home of a sitting judge of the Punjab and Haryana High Court called Nirmaljit Kaur, and it was meant to be a bribe. The intended beneficiary of the bribe was actually another judge in the same High Court called Nirmal Yadav. The courier who was entrusted with delivering the bribe turned out to be incompetent, and it led to Nirmaljit Kaur being startled by the arrival at her doorstep of this unexpected bounty. She promptly reported the matter to the authorities, who, after some investigation, quickly discovered the identity of not only the bribe taker, but also the bribe givers, who were a couple of businessmen, aided and abetted by a practicing lawyer and another person, probably a middleman. The matter was duly reported in the media, but if the journalists who reported it had been charged with contempt, I can see that they could have easily used the defense of truth coupled with public interest and good faith. Now, can a judge himself or herself be guilty of contempt? The answer is yes. And we have a fairly recent example in the form of the former Justice C.S. Karnan, whose case is extraordinary by any standards. This case, which happened just 3 years ago, has an important lesson to convey. The central figure in this case, Karnan, was a judge of the Madras High Court. He had apparently been selected for the judgeship because he was a Dalit, and he appears to have had a chip on his shoulder based on his caste status. A couple of years after becoming a judge, he began a letter writing campaign in which he made allegations of caste discrimination by his fellow judges. His behavior became increasingly erratic and unruly, and some 20 judges of the Madras High Court requested the Chief Justice of India to transfer Karnan to another High Court, which the Chief Justice did in 2017. But Karnan continued his tirade from his new location, Calcutta, this time publishing an open letter to the Prime Minister alleging that some 20 Supreme Court and High Court judges were corrupt and needed to be investigated. When he was asked to show cause why action should not be taken against him for such outbursts, which of course were not in keeping with judicial decorum, he went on an offensive, passing all kinds of perpetual orders against sitting Supreme Court judges, including one in which he sentenced the then Chief Justice and 7 other Supreme Court judges to imprisonment for 5 years for alleged crimes against scheduled castes. The stage was now set for a showdown between Karnan and the Supreme Court, which, among other things, ordered a psychiatric examination of the man, clearly implying that he was insane. But Karnan became increasingly intransigent, and his actions were clearly obstructing the administration of justice. So the Supreme Court charged him with contempt, and after giving him a reasonable opportunity to be heard, sentenced him to 6 months imprisonment. This was followed by further drama because Karnan evaded arrest for some 6 weeks, during which time he officially retired as a judge. He was finally captured and taken to a prison in Calcutta, where he served his sentence. Incidentally, he's been in the news recently because he was arrested in Madras for upholding a video containing obscene, defamatory remarks against several former and current judges of the Supreme Court and High Court, their wives, and certain women judges. The Karnan case, unfortunate though it is important because it shows the need for criminal contempt to be retained as an offense. Without such an offense, outrageous actions like those of Karnan cannot be dealt with effectively. So the message which this case sends out is, don't throw the baby out with the bathwater. Another slightly troubling case which came up recently concerned a practicing lawyer called Yatin Oza in the Gujarat High Court. This lawyer, who is also the president of the Gujarat High Court Advocates Association, addressed a press conference in which he accused the court registry of corruption and malpractices, as well as calling the High Court itself a gambling den, presumably referring to the unpredictability of how cases would be decided. The Chief Justice apparently set up an in-house committee to investigate the charges made by Oza, and that committee came to the conclusion that Oza's charges were baseless. Oza was proceeded with and convicted of contempt. He was slapped with a token sentence of imprisonment till the rising of the court and a fine of, I think, 2,000 rupees. More controversially, the court also, in a separate act, stripped him of his title of senior advocate, something which seems to have caused him more anguish than the fine. He appealed those decisions to the Supreme Court, where the proceedings have dragged on since last October. Yet another form of criminal contempt is when someone takes photographs or makes an audio recording in a courtroom. The prohibition on taking pictures, etc., has been a long-standing rule in courts in most countries, because in the days before miniature recording equipment became common, those actions would have had the tendency to disturb proceedings and thus interfere with the administration of justice. But the rule is being relaxed gradually, and some countries are now allowing judicial proceedings to be filmed and broadcast. There have been plans to introduce live streaming of proceedings in some Indian courts, but those plans have not gone very far, except in the Gujarat High Court, some of whose online hearings are now routinely live streamed and can be watched by anyone. I must say that they're actually quite interesting. Let's now turn to confidentiality of sources. This has landed many journalists in trouble. As you know, journalists frequently cite anonymous sources in their articles. Can a court compel them to reveal those sources? The answer is yes. When that happens, there's a clear clash between the law and ethics, because media ethics require a journalist to honor any promises they may have made to their sources. And finally, what are the defenses that are available to someone charged with contempt? The main ones are innocent publication. For example, when you do something which might interfere with the pending trial without having a reasonable cause to believe that the trial is pending. Secondly, publication of a fair and accurate report of a legal proceeding. Thirdly, fair comment or criticism of any judicial act. Fourthly, complaining against a judicial officer in good faith. Fifthly, publication of information about in-camera or private hearings in certain circumstances. Also, there is a defense of proving the truth of contemptuous remarks, as long as it's done in the public interest and in good faith, as I've already pointed out. The punishment for contempt under the 1971 Act is simple imprisonment for up to 6 months or a fine of up to 2,000 rupees. But the court has a duty not to punish if an apology is tendered in good faith or if the alleged act does not substantially interfere with the administration of justice. Also, every convicted person has a right of appeal against the conviction. Furthermore, no action for contempt can be brought after 1 year following the date on which the alleged act was committed, which is another safeguard against the abuse of the contempt law. I hope I've given you a fair idea of how contempt law operates. Sadly, I did not have enough time to deal with many other aspects of this subject, but I'll be happy to answer any questions that you may have. Thank you very much.
Thank you, sir, for a very insightful session where you could cover up, so many things and with so many cases as well, which you can easily relate to. Just to convey, Puri ma'am, she got an urgent call actually, and she had to leave actually. So, this was just to convey. Before we start with the question answer sessions, I request Professor Paul if he wants to share something.
Thank you very much there, Vikas, and thank you, Venkat, for a tour de force in terms of your presentation. Given with the usual sobriety for which you have become renowned, but your anecdotes, nonetheless, I found very amusing. And having accompanied you on several trips to India, including to a scene in the court, which was remarkably low-key, I'm advised, by reference to some of your own experiences as a lawyer operating in India some years ago. I found it nonetheless still a fascinating experience. A couple of comments. You talked about the role of social media, and indeed, as a political scientist myself, I think your lecture is timely for all of the ongoing debate about the power of the social media empires and their capacity to, as it were, cock a snoop at both the legal fraternity as well as the political establishments in various countries, as we're seeing, for example, in Australia most recently, but also here in the UK and in the United States, as well as, of course, in India. I'd like to just as well at this point say that, like Venkat, having visited Nirma, we're looking forward very much to coming again. Unfortunately, as he pointed out, the pandemic restricts us from doing so. But in the meantime, I think it is a measure of Nirma's foresight to have launched this International Education Week, or month rather, of events involving distinguished scholars such as Dr. Iyer, but also with your partners around the globe. And I'd like to commend you for that foresight and, in a sense, bringing the world into you, your staff and your students, whilst the pandemic prevents direct engagement in person. So again, just a note of congratulations to you for having this event, and I look forward to hearing some of the questions and answers.
Thank you, sir. We got a question where he says that when media is presenting facts on cases which are sub judice, or sub judice reporting that is going on, the sensationalized manner in which they report, and what do you think why the Indian courts, for that matter, choose to remain silent even when at times a trial is going on? And he wants to know whether there is any law in the UK which makes these large broadcasters also liable for some sort of a reporting of this kind when the matter is going on, actually.
The answer to the second part of the question is very clear and short. Yes, broadcasters are covered as much as newspapers and other news sources are concerned, media sources are concerned. On the first part of your question, actually, I'm quite surprised that your questioner thinks that Indian courts are quite reluctant to take action. If anything, in my experience, Indian courts have sometimes overstepped the line when it comes to sub judice matters, because generally speaking, there seems to be inadequate understanding of how the sub judice rule either originated or should operate. So as I briefly mentioned in my lecture, the sub judice rule was essentially created to stop juries being influenced by extraneous comment when a case is pending. Now, in India, of course, you don't have juries. So to that extent, actually, the sub judice rule has far less significance than in countries like England. So therefore, I disagree with the premise of the question. But generally speaking, I would say that there are circumstances where if media comment is such as to influence the proceedings or the outcome of the proceedings, then clearly some action needs to be taken. And I referred to the case of Arushi Talwar, which to my mind comes close to that sort of a situation.
Perfect, sir. Just one more question. I think we can have another one where the participant is looking for an answer to the question, like when you said that there are cases when things can be a subject matter of both defamation as well as contempt. So I mean, what is your views on where do you draw that line, and to come up with a segregation sort of where we divide the line between a contempt and a defamation, which can be something of a kind.
Okay, generally speaking, defamation is something that affects personal reputation, that is the reputation of a judge, and contempt is something that strikes at the administration of justice. So it is possible in certain circumstances for an attack in the media, for example, to be so scurrilous and so unfounded that it could cross the line between acceptable comment and unacceptable comment and become contempt of court. In other words, it is shaking public confidence in the administration of justice. But it could also be a comment that is defamatory of the judge because, first of all, the comment is untrue. Now, do remember that it is not possible to take action for defamation in respect of a true statement. So for defamation, the threshold condition is that the statement has to be untrue. And of course, in the case of criminal defamation, in addition to the statement being untrue, there should also be a public interest in any proceedings being brought. So in the limited time that we have, that's probably the most compact answer I can give to that question.
Absolutely, sir. So I think with this, we come to the end of the session. On behalf of Institute of Law, Nirma University, I record my sincere thanks to you, sir, for coming up with a very great insights on this very interesting theme of contempt of court and the free speech aspect, where you could, so many things, trial by media and the social media part that also you touched upon. So this was a very comprehensive, sort of a complete package, I should say, when it comes to the contempt of court and all. So thank you so much, sir, for your session. And thank you all the participants as well. Thank you.
Thank you, Vikas. And can I also thank yourself, your colleagues, everyone involved in putting this together, and to simply express the hope that next year we'll all be able to meet in person. Thank you.
Perfect. Thank you, sir. Thank you.
Thank you so much, sir.